This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon. Before we start, just a couple of things. If we should have any difficulty with the technology or any problems with this, we'll simply take a pause and work through it and then pick back up. We understand the lovely weather that you are dealing with down there. But hopefully we won't have any, we don't anticipate any problems, but just in case. Stephen, call the case, please.
State Ex Rel. James Frederick Roberts v. Elizabeth Dale Crafton.
Mr. Roberts, we'll hear from you.
Good afternoon.
Good afternoon.
This is kind of strange on video. Yeah, this is a post-divorce litigation case that started with problems over in circuit court. I'm going to touch on three main topics. The main argument is the original parenting plan. It bars the use of the child support guidelines until the children reach this, get out of the sixth grade. I've been trying to argue that my attorney was just barred for trial, so I had to represent myself. That's when I started researching this stuff. And in the parenting plan, it states when the children have reached the age where Christ Methodist School is no longer an option, the parties agree that the children will attend private school chosen by mother. At that time, father's obligation to pay his share of private school will cease. Any child support obligation will be limited to the amount of support pursuant to the child support guidelines without consideration of the tuition amount paid by mother. Mother agreed to this. She initialed the parenting plan. She's bound by that. That can't be changed. Circuit court has to change that. So after the sixth grade, I'm legally not responsible for child support. I'm not legally, that's not my duty. Mother's agreed to it, she's bound to it. But here's the deal. The child support section that bars the use of these mother, immediately when the first child graduated the sixth grade, mother was on top of it. She read it the same way. We were allowed to use the child support guidelines then. It's void. That's my main argument. That part's void. It bars the use of the child support guidelines. I struggled. These kids struggled with father. There's no equity between the homes. That was one of my main arguments. Number two, when we get it over to mother gets it over to this case over to juvenile court, Magistrate Kessler sets aside this order. She modifies this order. It's a parenting issue. Mr. Reidnauer, in his brief, states disputes between parents regarding educational decisions are submitted to the divorce referee, Anderson versus Anderson. To the extent a request for relief would lead to modification of the parenting plan's provisions, jurisdiction in that matter would be Shelby County Circuit Court, not juvenile court. Mr. Reidnauer solves all the problems himself with this one statement that juvenile court does not have subject matter jurisdiction to modify a parenting provision. That's a parenting provision. Mother's bound by that. That solves all our issues should solve all our issues over in juvenile court. That's my number two argument. Magistrate Kessler was out subject matter jurisdiction of modifying a parenting provision in the parenting plan. And none of the judges will listen to that. So my argument number three, fast forward to our current situation. This was on remand from the appeals court because the state had filed a petition. Anytime you plug the numbers in, from all the way back to the beginning, mother would owe me child support. Always. But that never came about. And when it finally did come about, Magistrate Kessler said that where mother was paying child support to father, well, Mr. Reidnauer files a motion saying that my motion to modify was not proper. So on remand from the appeals court, this comes back to the appeals court because of what because it wasn't a final order, because the state filed a petition for a rehearing that dealt with only the way that money was entered into the system. That was all that we were supposed to be solving. Mr. Reidnauer goes before the court and starts claiming that my motion to modify was not proper. Well, his motion to modify, his response was not proper either. He was outside his time limit. So his stuff's improper. He's got an untimely response. So that he's waived all his defense to even complain about my motion to modify. That's my third main argument. Mother has no defense because she's waived it all. She was not timely on her response. And once an obligor parent makes out a prima facie case for modifying his child or child support, the burden shifts to the custodial parent to prove that the requested modification is not warranted by the guidelines. I was laid off. It was a company layoff at my job. And I put that in my motion to modify. That's in there, and my request to for anything that my argument is it was a motion to modify. Magistrate Kessler told him once before, standing in court, the state was standing there right with him, Mr. Reidnauer, it is a motion to modify. I was laid off from my job. I don't have to meet a significant variance because they gave me income that wasn't verifiable. I can't remember what it's called. But I lost my train of thought. All right, I still got 3 minutes. I'm gonna read one piece of the case law. This court recently determined that even a waived, defendant attempted to revive an affirmative defense that should have been pled years early. Once an affirmative defense is waived, it is waived. Once an affirmative defense is waived, it is gone. We find no case law or statute that permits it to be unwaived. That's Terns versus Kalicia, Tennessee. And that's my 3 arguments.
Okay, anything else, Mr. Roberts, right now?
No, sir.
All right, you have your time. You have your time for rebuttal after we hear from the appellees.
Thank you.
There's going to be one argument on this side for the appellees, or more, or 2.
There are going to be 2 arguments, Your Honor. I'm going to begin, and Mr. Reidnauer is going to finish up.
Okay, so you've divided the time up, I see.
Yes, Your Honor.
All right. Mr. Roberts, just so you understand, they divided their 15 minutes up, so they get the same amount of time you had total. Okay. Thank you, please.
May it please the court, my name is Kristen Kyle Castelli, and I am here on behalf of the Department of Human Services. Your Honors, this case has a complicated procedural history. I hope to clarify some of the procedural and substantive issues before the court. There are 2 orders at issue in this case, the April 2019 order and the Juvenile Court order denying Father's Rule 59 request. Father's 3 motions at issue in this case are his motion to vacate, his amended motion to vacate and or modify, and his Rule 59 order. Father's primary contention is that the
Counsel, let me ask you a question.
Yes, Your Honor.
Has the motion or I guess the motion for rehearing been determined yet?
No, Your Honor.
What's the status of that?
So with the motion to supplement, Father claimed that he had struck that motion, and how that all came about is after the appeal was filed, there was a Father filed a first motion to modify post appeal. The Juvenile Court then adopted the magistrate's order modifying the April 2019 order. Mother asked for that to be set aside, that led to this court's limited remand. Father asked for the request for a rehearing. There's nothing in the record that says that was ever completed post appeal or it was struck.
Did we not remand it for that to be taken care of?
Yes, Your Honor. The magistrate considered and set aside the order that was modifying the child support post appeal. But then Father asked for the request for a rehearing, and it doesn't appear that was ever complied with by the Juvenile Court.
All right. Did we get anything from the Juvenile Court? after our remand?
As far as the magistrate did consider it, and that is in the record that the magistrate considered it and set aside the order. There's actually a corrected version as well because the juvenile court magistrate failed to sign it the first time, but we don't have anything to say that the father's request for a rehearing was ever complied with.
Do we have, where does that leave it?
The state's position is that after 17 months, it would be appropriate for this court to essentially revoke the limited remand and reacquire full jurisdiction and affirm the 2019 order as the final order. Because when the juvenile court considered the post-appeal motion to modify by father that was filed by father, they were acting without jurisdiction because he was attempting to relitigate the same issues that are currently on appeal in this case.
Okay, go ahead.
Okay. I have attempted to distill father's substantive arguments, and I plan to address the following four points for this court. First, father failed to specify which circuit court order he was challenging as void in his filings. Secondly, he failed to produce evidence that the 2008 order or the 2013 orders were void. The 2008 order was not void for violating public policy by barring future modifications. And finally, the contractual agreement incorporated into the 2008 order merged into the decree, allowing the juvenile court to exercise subject matter jurisdiction and modify the agreement in 2013. For brevity's sake, I will rely on my brief to address any procedural issues. But first, the juvenile court didn't abuse its discretion in denying father's request to vacate the circuit court's order because father failed to specify which order he was challenging as void. I will proceed by assuming that he's challenging the 2008 order, which is located at volume 1 of the technical record, pages 38 through 46. Secondly, father seeks to set aside the 2008 and 2013 orders because he failed to appeal either one of those orders. Neither order is void, and only void orders are subject to collateral attack, which are allowed if the court didn't have subject matter jurisdiction, issued a judgment wholly outside of the pleadings, or the person is shown by the record not to have been present in person or by representation, and father failed to produce any evidence regarding either order that was the case. The trial court did not abuse its discretion in denying his relief. As far as father's assertion that the orders couldn't be, the 2008 order was void for violating public policy by barring future modification, that argument is without merit because the order was indeed modified in both at least 2009 and in 2013. But finally, the contractual agreement incorporated into the 2008 order merged into the decree, which allowed the juvenile court to properly exercise subject matter jurisdiction and modify the agreement in 2013. TCA 365101J allows for an agreement between the parties as to child support. In Berryhill versus Rhodes, the Supreme Court held that a contractual agreement would be upheld if it was in writing, approved by a court, incorporated into a court order, and contained the parties' acknowledgement they may not alter without court approval. Here, the 2008 order contains all of the provisions required by law. As the Supreme Court recognized in Penland, a contractual agreement with respect to the legal duty of child support, upon approval of that contract, the agreement merges into the decree and loses its contractual nature. Here, father agreed to pay the private school tuition in lieu of child support. The circuit court approved that agreement, and the contractual nature of the parties' agreement merged and was subject to subsequent modification, which is what actually occurred here. The post-appeal procedural history is quite confusing, Your Honors, but the state would recommend that the court revoke its limited remand, reacquire full jurisdiction, and affirm the April 2019 order to proceed with the substantive issues. And DHS does not oppose supplementing the record to shed light on whether father actually struck his request for a hearing before the judge. DHS reviewed the post-appeal filings, and it didn't appear that the juvenile court judge either struck it or heard father's request for the hearing before the judge. But the trial, substantively, we do not believe that the trial court erred in denying father's request pursuant to Rule 60.
All right, I'll make sure that I understand where we are on that point particularly. We remanded it back, or remanded it, and the trial or the juvenile court ruled on father's motion, correct?
Yes, Your Honor.
All right, now is that in the, do we now have in the record his ruling?
Yes, Your Honor. There was the juvenile court filed a post-appeal modification on July 16th of 2019.
All right, after remand, the juvenile court ruled on father's motion, correct?
Yes, Your Honor.
And we have that order from the trial, from the juvenile court in the record.
Yes, Your Honor.
And then father filed a petition to rehear on the juvenile court's ruling on that, right?
Well, at that point, filed a Rule 60 and requested a limited remand from this court, which was granted on September 10th of 2019.
Okay. Well, all right. So we remanded it to the trial, to the juvenile court to rule on father's motion.
To rule on mother's motion to set aside.
But mother's motion to set aside.
Yes, Your Honor.
All right. And the juvenile court ruled on that?
The magistrate ruled on that.
Yep. All right. The magistrate ruled on that. And we have that ruling in the file, in the record.
Yes, Your Honor.
And after the magistrate ruled on that, what happened next?
After that, father filed a motion to the request for a hearing before the judge.
All right. And that's what is still out there.
Yes, Your Honor.
Is that request for a rehearing, is that actually in the record?
That is actually in the record.
So we have everything up to that, but nothing happened on that.
Nothing happened on that. It's a little bit more complicated with a second motion to modify that was filed post-appeal. Father does, in the post-appeal filings that we were able to find, father requested a strike to strike his request, and the magistrate struck his first post-appeal motion to dismiss.
All right. So what, if anything, is left down below?
I believe the only thing that is left down below is the request for a rehearing before the judge.
Father's request.
Yes.
Okay. All right. Thank you.
Thank you.
Let me ask one question. Do we know if that request has been made, or has the hearing been scheduled, or do we know anything about that at this point in time?
We do not. It doesn't appear that it has ever been scheduled, Your Honor.
Okay. Thank you.
Okay. All right. Thank you, counsel.
Thank you.
Okay.
May it please the court.
Yes.
Thank you, Your Honor.
Yes,
My name is Jason Reidnauer. I represent the appellee Elizabeth Dale Crafton, the mother in this case. Before I get started with addressing any of the arguments that Mr. Roberts had made, I do want to address this post-judgment issue because it is confusing, and I hopefully can state that there's nothing, in my opinion, and I believe that's based on the law, that's left for this court to that this court needs in order to issue an opinion in this case. And here's why. We have a final order in April of 2019. There was a Rule 59 filed by father, which was ruled on in May of 2019. So we have a final order as of May of 2019. After that final order was entered, father files a motion to modify child support, which he subsequently submitted a request to voluntarily dismiss that motion. There was a mistake in the record. And what happened was the magistrate, in basically recognizing that motion to modify post-judgment was not appropriate, essentially stated this: we are reinstating the order of the court. And what happened was the wrong order was put in the court's July order. So instead of essentially following the May 2019 order, the court revived an order that had been set aside previously. So it was just
the March 2016 order.
Yes, Your Honor.
All right.
So in effect, that order was void. I mean, I don't think there's any question that a junior magistrate can overrule the order of the substitute judge. I mean, there's no basis in law, and certainly there was no request to do that. And so that's why we asked for the limited remand, not because we thought that this court couldn't rule on the final order, because a void order, this court could clearly see and essentially ignore and say, well, we're not going to consider that. And maybe in this court's mandate, maybe direct the trial court to clean up the record for purposes of clarity. But in terms of having a final appealable order for this court to review, that void order doesn't affect it. The only reason why, or mother rather, requested a limited remand was because of the enforcement structure of the state child support system. We certainly didn't want that void order to get lodged into the state child support system and it caused license revocation or petitions for contempt. So that was the reason for the motion for remand. And it was very specific. The limited remand was very specific to, based upon this court's order of September 10th, 2019, for the consideration of mother's motion. And that's what happened. It went to the magistrate that made the mistake. The magistrate made the mistake, Magistrate Kessler, reviewed the motion and said in the order that is lodged in the court's record that I made a mistake and the court is correcting it. So what happened then was, prior to that, Mr. Roberts had filed a response to that motion and essentially made a counter motion for Rule 60 relief, asking also essentially restating what is currently on appeal, this void order issue and everything. So really, for all intents and purposes, Mr. Roberts' request for rehearing would essentially be an inappropriate request anyway, because he's asking for relief that he didn't ask this court to remand for the trial court to have jurisdiction over. The only thing the trial court had jurisdiction over was directly related to the remand of this court. And if you look
but wasn't his Rule 60 request for here, did it apply to what the magistrate or the juvenile court, whoever did it, on remand?
No, it raised additional issues. It raised issues basically restating the request of the trial court to find that the 2008 parenting plan was void and therefore voided the entire last 12 years of orders. I mean, that's what his request was. It was an inappropriate request. But I think what's important to note is that the request by the state to revoke the remand, so to speak, and to bring it back to the court, I mean, that's entirely appropriate because this is all based upon a void order that has nothing to do with the finality of the May 2019 order. So the scope of the record between 2015 and May of 2019 is unchanged, regardless of what happens on the rehearing notice. So I think it would be essentially be a travesty to remand back down for another several months. And I'll tell you why. A couple of reasons. One, the remaining child is going to be aging out in a couple of months. So
in April, I believe.
In April, and so we're going to have a graduation in May. We're on track to do that, which means that we'll be, in all intents and purposes, coming back here in 2022, arguing over a child support order from 2008. And I just submit to Your Honor that there's nothing in the record that would require this court not to exercise its jurisdiction, specifically because of the fact that it's dealing with a void set of circumstances that occurred after the judgment. So Your Honor, I think, going back to Mr. Roberts.
Let me ask you a question, Mr. Reidnauer.
Yes, sir.
And so if we look at the record now, will the order actually reflect what is transpired? Will we be able to put it all together by reading that order? Because you said initially the wrong order was used, but now the magistrate recognized the problem and corrected that. So it will all fit together. Is that what you're saying?
That is absolutely correct, Your Honor. There is there's an order in the file. It's an order from October the 3rd, 2019. I don't have oh, here it is. It's in volume 5 of the transcript, starting at page 786. And that order very clearly states exactly what happened, what the mistake was, and what orders were essentially operative for purposes of child support.
Okay.
Thank you, Your Honor. So just to very quickly state, I'm not entirely sure how much more this court needs. I think both the state's brief and our brief tried to be as complete as possible regarding, these very frankly interesting but simple legal issues that are overcomplicated by a bunch of filings that were made by Mr. Roberts that unfortunately has clouded things. I think what's important to note is I just want to correct a couple of things. Mr. Roberts stated his attorney had been disbarred. He was represented by counsel in the 2014 order, the 2013 proceedings, and there could have been an appeal. He waited 468 days after the ruling of the court in October of 2013, in October 2013, to file a Rule 60 motion. And so that's what we're dealing with today. There was never a proper request for a motion to modify child support. The court properly ruled, and the record is clear.
Okay, thank you, counsel. Mr. Roberts, we'll hear from you on remand.
Yes, sir. You ready?
Yes, sir. Let me ask you a question to start with here. Is what's left down below, is it your October 8, 2019, where you filed a notice request for hearing before the judge of the magistrate's ruling?
Your Honor, when I was going through, I'm ADD. So when I'm going through this, I told the judge I was going to strike that motion. Apparently I struck one of the motions, and I just thought I had struck that one also. I don't know. I'm not even for sure. You can't get to the record. I couldn't get to the record down.
Well, let me ask you a question here, see if we can simplify this. On your October 8, 2019 notice of request for hearing before the judge, are you saying that you intended below and intend now to basically withdraw that notice, that request?
I'm still having problems trying to figure that out. I can't answer that honestly. I don't know. I can't see the full record because you can't get down there to look at juvenile court. The record's it's always checked out.
Well, that was the last thing. That was the last thing that you filed. I think that was the last thing anybody filed down there.
Right.
And did you? Maybe I misunderstood. I thought you said you intended to tell the judge down there that you were striking that request for a hearing before the judge.
That's what I thought I did.
Is that what you want to do?
I don't understand what Ms. Castelli was talking about just then about setting it back to the 2019 order. It's too much for me to process right now. I didn't understand what she was saying about that. It would set it back to the 2000. They gave mother a retroactive modification of child support. They set it aside. She owed me. They set that aside. So I don't know what she was. I got to re-listen to this to understand what Ms. Castelli was saying.
Okay, but I'm trying on this because our jurisdiction is sometimes limited on what.
I'm so sorry.
We'll work through it. The last thing that was in there after remand was the magistrate granted the mother's motion to set aside that July 16 order. Then on October 3, then on October 8, you filed your notice of request for hearing before the judge.
Sorry.
And I think that was it. That was the last thing as far as we know. And you, as I understood it, you told us that you intended to strike your notice of you intended to strike that October 8 notice of request for hearing, correct?
I think so.
Okay. Well, it was the last thing you filed.
Okay.
Okay, I understand. Go ahead. I'm sorry. Proceed.
All right. So I'm so sorry. I thought I turned my phone off. I didn't. I apologize for that. First thing I want to touch on is Ms. Castelli. She said the original parenting plan does allow for a modification, but the two spots that she's talking about are, it says, should the parents disagree about this parenting plan or wish to modify it, they must make a good faith effort to resolve the issue by the process selected below before returning to court, except for financial support issues, including child support, help, blah, 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 blah. It says except for, so that's not a modification to me. That's not, it doesn't work. And in the other spot she's talking about, it talks about decisions. It also says except for private school, meaning mother it's already, other than the choice of school, educational decisions, it's already made. Everything's joint. That's the two places that she's talking about. It does allow for a modification. Well, except for school, that's what I through this whole thing, I'm PRP of one of these kids. I was PRP of over in juvenile court. I went to circuit court and I filed a motion to try to get my kid in public school, and I went to Magistrate Kessler in juvenile court. If none of these courts will give me relief, allow me to put my kid that I'm PRP of in public school, where's the relief valve? Where do I go? Who do I talk to? The court won't help me. So that's my argument. Neither court would let me put my child that I'm PRP of into public school. That's not justice. That's not justice. Mother's family are millionaires, and she's just admitted that she came into her inheritance. And I subpoenaed over $100,000 worth of checks made out from the trust, from the parents' trust that's paying for this public school. Mother doesn't even pay for these private schools. She didn't pay for them herself. There's a trust that's paying for it, but she wants me to pay for it. That's not right. The other thing,
Mr. Roberts, your time is up, but we'll give you a little bit to just kind of wrap it up quickly here.
well, the main thing, I guess I'm finished. The main thing was that I was PRP of one of the children. If you can't go to the court and get relief, put your child in public school, they stop me at every circuit court would say, well, that's the jurisdiction of, that's in child support over in juvenile court. That's the jurisdiction over there. And then juvenile court, I'm done. I'm sorry.
No, that's it. Let me ask you one last question. If you prevail here, I'm not saying one way or another, but if you should, what relief are you asking this court? What are you asking us to do?
Well, to be honest, take the private school tuition out of the equation. So just take it out. Just take it out. That's fair.
All right. Thank you, Mr. Roberts. Thanks to both sides for your oral argument today. Mr. Robert, you may already know this, but I'll tell you to make sure that you do. We'll take this under advisement, and then we'll arrive at a decision in due course. And then we will issue our written decision and send it to you and the two lawyers on the other side at the exact same time.
Thank you.
Okay. All right. Thank you. Mr. Hivner, if you will, adjourn court, please.
This honorable court is now adjourned.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you.